right? That's the goal. But whenever I do these risk management seminars, I always ask the group, back pre-COVID, it was all in person. And I'd say, what can you do to prevent being sued? And I would have people raise their hands and say, disclosure and honesty and all these buzzwords, which are all true and correct. And after, 4 or 5 people volunteer some information, I say, thank you for participating. Everybody that raised their hand and offered, all of you are wrong. And they look at me and they say, you mean we're not supposed to be honest? We're not supposed to disclose? And I said, no, you missed the call of the question. The call of the question is, what can you do to prevent being sued? And the answer is nothing. You can't stop the mechanical filing of a lawsuit unless you sit down at the clerk's office for the next 3 years between the hours 8:30 and 4:30, excluding legal holidays, to see if a former client's walking in a piece of paper and a checkbook. So there's nothing that you can do to prevent being sued, but what you can do is, and I'll go over some of the things, but you can help me help you when you get sued. And I say when, because it's a matter of time. I've been doing this for 15 years in California, 6 prior in Texas, different world. But I've had clients that got sued on their very first transaction. Ink on the license wasn't even dry, and they already got sued. They were saying, I just don't think this is for me. I just got sued. I just got my license. This is my first deal. And I said, no, you're not a real realtor until you get sued. I said, you got that one out of the way, go about your business. On the flip side, I've had a broker client of mine a few years back, got sued on her last transaction after 43 years. Thousands of she got sued on her very last transaction. So what can we extrapolate from that? I think there's a misconception that the younger you are in the business, the more likely it is that you're going to get sued. Whereas if you've been doing it 10, 15, 20, 30 years, you know everything and you're Teflon Don and you're not going to get sued. That's just not true. So when I have clients, that I speak with, I say, I've been doing this for 22 years and I've never been sued. I say 2 things. First thing I say is congratulations. The second thing I say is you haven't met the right plaintiff yet, because they're out there. They don't want to spend their money repairing their property. They want to spend Tom's money improving their property. So the GE stove prior to close of escrow becomes a Viking stove in litigation. The linoleum floors prior to close become, hardwood floors in litigation. And that's just the reality of it. And so what everyone can do to help me help you if and when you get sued is memorialize everything in writing. That is the most important thing that you can do to help me help you in a lawsuit. If it's not in writing, it never happened. So we have the proverbial liar's contest, right? That's what we want to avoid. And so I ask clients all the time, so here's a lawsuit that says, 5 things weren't disclosed. Did you have any conversations with your client about these 5 things? And oftentimes my client will say, oh yeah, absolutely. I say, anything in writing? No. Okay, well, they're going to perjure themselves under oath, and they're going to tell a story that never happened. It's not what you know, it's what you can prove. That's the most important thing to take away from this. Memorialize every significant, especially on the buyer side of the transaction, every significant issue that comes up. Whether there's red flags in reports, are you making additional recommendations based upon those red flags? And as you on the buyer side of the transaction, you're calling balls and strikes. That's really what you're doing. You're issue spotting and you're looking for red flags. If you were buying this house, what would concern you based upon all the disclosures and all the reports, and who would you call? What third-party vendor would you call out if you were the buyer? Those recommendations to your buyer need to be made. And they need to be made in writing to prevent the proverbial liar's contest. So at the outset, that's the most important thing that I can say. Tom, did you want to go over some of the kind of questions, topics, issues that Mark sent over? Or
Yeah, absolutely. I've got a few here that I know come up frequently, and if you could elaborate on them, that'd be great.
Yeah.
I was going to ask, what are the risks of escalation clauses in purchase agreements?
So hopefully everybody understands what escalation clauses are. It's generally where you're going to submit an offer and say, and we'll pay 5,000, more than your highest offer. Okay. So here are the problems with that. So in California, for a contract to be enforceable, there's three things that need to be in the contract: description of the property, the address, who the parties are, the buyers and the sellers, and what the price is. All the other terms can be inserted with respect to contingency periods and whatnot, but those are the three most important critical components to have an enforceable contract. Okay. The purchase agreement also has what's called an integration clause. That's a fancy word for, if you look at the RPA, it'll say something like full and complete or something along those lines. So all an integration clause is the agreement between the buyer and seller are contained within the four corners of the document. Okay. Any oral discussions, negotiations that are outside the written agreement cannot be considered. Okay. They're extrinsic to the contract. So if you're using an escalation clause, price is not set, right? We'll offer you $1 million plus $25,000 over your highest price. Well, what's the contract price? It's not set yet, right? So that is an unenforceable contract until that last addendum is signed off on. And including the word not to exceed. Once again, whenever you're qualifying the purchase price, is exactly what escalation clauses are. It's a qualified offer, right? Subject to further determination. It ultimately is an unenforceable contract until that last addendum is drawn on price.
Got it.
So
what types of issues are you seeing arise from non-contingent offers?
So popular real estate device these days, considering the low amount of inventory. Non-contingent, I don't like non-contingent offers. I know that it makes the offer look more attractive to a seller. And when you've got buyers that are getting beat out of multiple properties, they start getting desperate. They start wanting to have a more aggressive, more attractive offer to beat out the other buyers. But the problem with non-contingent offers, there's problems on both sides of the transaction. A seller accepting a non-contingent offer can create an environment to where a buyer alleges in a lawsuit that the seller and the listing agent were all in cahoots and knew that the seller wasn't going to be able to get the asking price if certain things were disclosed. And so there's no inspections, therefore, okay, there you have it. On the buyer's side of the transaction, non-contingent offers, let's say escrow closes, they didn't do inspections, weren't entitled to inspection because it was a non-contingent offer. They basically waived their contingencies, and escrow closes, problems come up. Next thing you know, the buyer's calling you saying, hey, we've got all these issues that we're now discovering that could have been discovered through an inspection period, and you talked me into a non-contingent offer. What can also happen with non-contingent offers, which if not explained, and I've actually seen a couple of these types of lawsuits, non-contingent offer, which means if buyer doesn't close escrow for any reason, don't care what the reason is, the buyer doesn't close escrow, that earnest money deposit is subject to forfeiture to the seller. So if your buyer is aggressive and wants to write a non-contingent offer, you need to make sure that you disclose in writing. Email is fine. The consequences vis-a-vis their deposit if they don't close. Oftentimes the consequences of actions aren't thoroughly explained to buyers. Similarly, when buyers remove certain contingencies, let's say it is a contingent laden offer, the buyer's going to remove their loan, appraisal, physical, the concept, even though the contingency removal form in the contract tells buyers, hey, once you remove this contingency, you can't cancel based upon that contingency. It's because it's no longer at play in the transaction. And if you don't close and you're trying to point to a removed contingency, your deposit is subject to forfeiture. So are you sure you want to remove this? And have that dialogue where you're explaining to your buyer client the consequences of their actions. Okay. So with non-contingent offers on the seller side, to try to avoid what I've already described on the seller side of it, there's a couple of different options, suggestions that your seller can take. They can counter it out. They can put an inspection period back in on a counter, right? Have the seller get inspection reports of the property, home inspection report prior to the close of escrow, and front load that report, and even certain disclosures about conditions of property. Front load that prior to the seller accepting the offer, and that's very similar to the way Northern California transactions work. They front load prior to acceptance all of their disclosures, including historical disclosures when they purchased the property. Whereas in Southern California, we kind of lie behind the log. We have our stuff over here, and then after the price is agreed to, then we open Pandora's box and say, well, here's all the stuff that's wrong with the property. Then we're renegotiating price or credits and form a request for repairs. But it's a little bit different, Southern California versus Northern. So you can do that. You can put in the MLS. There's a holding period. We're accepting receipt of offers. We're going to hold those offers for 7 days or whatever time frame. Have buyers conduct their inspections prior to accepting a non-contingent offer. So at least they're going into contract formation after putting eyes on the property and having some inspections done. But on the buyer side, explaining the consequences of non-contingent offers is in writing is vitally important.
That's a good point, Stuart, because when post-COVID, when the transactions were going just cray-cray, I always knew as broker that, it will come back to bite us in the booty later, because all these people are not even doing inspections and they're waiving this and they're waiving that. Thomas, have you seen an increase post-COVID?
31%. Yeah,
stuff?
31% year over year, actually, for the last 2 years. We typically see an increase in claims when, you have the interest rates go back up, the market kind of tables off, people get buyer's remorse.
Is Thomas fading out?
They
or
thought they were going to get ceases. It was a market like that.
Yeah. So it's a good standpoint, as Stuart said, to go ahead and if you're having a buyer that wants to do a non-contingent offer, there's that non-contingent offer advisory that CAR put out a year or so ago to combat this. And just don't give it to them in DocuSign. You review it with them on what it means. And as Stuart said, then memorialize it in an email, because you guys hear me say that over and over and over again. Memorialize that conversation in an email to help you if in case it ends up. But that's great advice from the listing side too.
Yeah. And Bob, you actually raise a very good point that is very important. And I tell clients this all the time. If you were to, and this is based upon what I hear buyers / plaintiffs since 95% of lawsuits are going to be filed by buyers, buyers are enemy number one. That's who you need to look out for. They're the ones that are going to sue. Okay. And so I tell clients this all the time. If you were to take a very large conference room and you were to place side by side every single CAR prepared document in a real estate transaction, and you said it'd be a big table, but if you put those documents side by side, and I were to ask you, where's the buyer inspection election form? It's going to take you some time to find it. Why? Because all CAR forms, regardless of what they are, all look the same. They're the same size font, got the logo in the top left-hand corner, all right? They all look the same. So I hear in deposition all the time, they all look the same. Your client shoved it in front of me and held a gun to my head and forced me to sign it, essentially, okay? So I understand that argument and that play, okay? It resonates with some jurors, especially first-time home buyers. All these forms look the same. I didn't know, right? Whereas, what about an email? Does an email look similar? It's a personal note. It's not a form. It's a personal note to the plaintiff. So when you have, Bob, like you were saying, discussions with your buyer clients, for example, the consequences of non-contingent offers, having the CAR form talk about the consequences of non-contingent offers and having it signed and go over it with them is a good thing, because that's one exhibit that I have. And then I have an email. And maybe back and forth, where the plaintiff who's suing you claiming I didn't know the consequences, I've got a 3-page email back and forth where my client and the buyer plaintiff are talking about the consequences of a non-contingent offer. So it's much more powerful to document and memorialize things in writing and not simply rely on a CAR form. CAR forms are good, okay? But it's one of those old sayings that, what do you tell a guy with 2 black eyes? Nothing. He's already been told twice. Okay. So,
that was bad. Okay, thanks.
Right. So at some point in time, there's a law of diminishing return, right? So it's fine. And if you look at the SBSA, the BIA, pretty much say the same thing. Okay. So it's like, oh, and you sign this, and you sign this, and here's an email. It's like after the 3rd or 4th exhibit of like, we told you to do this inspection. It's like, yeah, we get the point. You've made
and
your
then
point.
get out of texting, because texting's great, but an email's a lot better.
So Bob, great point. There's something that happens between your brain and your thumbs with texting. Not to mention autocorrect, which can completely take the, what is this? Well, this is what it says. Well, that's not what I meant.
Yeah.
Well, that's what it says. Okay. So you're right. Texting, I'll see you at the house at 3:00 for the inspection. Fine. Hey, I'm going to send you documents over tonight. Fine. But anything of negotiating material terms, requests for repairs, price adjustments, credits, things of that importance, or write the consequences of writing a non-contingent offer, send an email. Yes. Send an email, because it's going to force you to sit down and think about what you're communicating.
We had a question from Amy. I saw your hand raised, Amy. Do you want to ask?
Yeah, so you had mentioned, Stuart, in regards to getting a pre-inspection on the property, putting it, I put mine in the documents tab of the listing, but I've had a seller come back to me because we received an offer on a property that had a lot of major issues structurally. And, I'd never got a bid on it, but it was in the report. And the buyer's offer came in at $1,050,000. I had not presented it to the seller yet. They were traveling back east and on the road. I couldn't reach them right away, but I confirmed with the agent that the buyer viewed the inspection report. And he said, oh, no, we didn't. They rewrote the offer and dropped the price $50,000. My seller was angry because they thought that we could have gotten in at $1,050,000 and negotiated that additional $50,000 as a credit. They didn't think they were going to have to put out that much. So we're walking a fine line here. How do we manage that when we should disclose through those reports, but then it affects the initial price.
Was that
And-
a non-contingent offer?
I don't remember if it was about a year ago. I think it was a non-contingent offer.
So it's, you know, there's not a one size all fits approach,
Yeah.
right? I don't have a crystal ball. You don't have a crystal ball. We can't look into the future and see what the effect or consequences are of front loading reports, right? If we all had that ability, I think we all wouldn't be working because we would have already hit the lottery, right? So, you know, I think if it's a non-contingent offer, those are ideas and suggestions
Mhm.
that you can discuss with, you know, your seller. You know, from where I sit, I'm not here to give everybody pats on the backs and hugs and say everything's going to be okay. You have nothing to worry about. That's not my job. My job is to get your antennas up to where you're starting to think about some of these things prior to a lawsuit, not having to learn them through a lawsuit. So, you know, does a seller have to get a pre-inspection report and give it to the buyer before accepting the offer? No, it's an option. And then there are discussions that can evolve with your seller, you know, about the pros and cons of taking whatever approach that, you know, we previously discussed. But if your seller wants to accept a non-contingent offer, fine. They're in the driver's seat. That's a stronger position for the seller to be in. But the downside is a buyer can claim in a lawsuit, they can spin that story of, well, you guys knew all the problems and you accepted my non-contingent offer. And so it's just one way to take a card out of a buyer's hands in a lawsuit, but certainly don't have to do pre-inspection reports or give it to the buyer, or, you know, have a waiting period so the buyers can do inspections. You don't have to do any of that. Those are just suggestions of how you can kind of curtail and push back against some of the buyer theories that they would assert in a lawsuit.
Okay, Toss, next question.
Yes, sir. Yeah, and well, actually, now that you brought up the car contract, Stuart, you know, have you has the change in the RPA resulted in any new types of claims?
From what I've seen, no. I'm just now seeing lawsuits that involve the new RPA. Most of the lawsuits that I have, even here in 2023, are the old RPA, which means lawsuits are being filed 2, 3, 4 years after close of escrow. Okay. The stuff that I have seen with the new RPA, you know, the first couple pages with the fill in the box summary, basically of the transaction. You have to be real careful and make sure that you fill out those first 2 pages very carefully. So attention to detail is important, especially in those first 2 pages. I've also seen, you know, with the new RPA, where they're using as additional terms, seller to pay Section 1 termite, which is kind of the old form, but they're inserting that into additional terms. It can be done. By the same token, it's generally more properly handled on a request for repair after a termite inspection's been done. Because if you're front loading, once again, that's the key word, right? You're front loading, hey, seller. So when you represent a seller, okay, it'd be good for the buyer to say, oh, seller, you're paying for Section 1 termites. That's good for the buyer. If you're on the seller side of it, how much are Section 1 repairs going to be? Don't know. So as the seller, you're accepting, I'll write you a blank check, right? If you don't know what Section 1 costs are going to be, you're signing your seller up for that for that bill. So you could counter from the seller's vantage point, you could counter back not to exceed $2,500 or some amount to cap or limit the seller's exposure to Section 1 costs.
I like that front loading. I often advise, especially in our metro market, because we have a lot of older homes, front load with a termite report as well as a good home inspection. So that when a buyer makes an offer, they're making that offer based upon an independent report, and they're not going to be shocked with any surprises when they go do their own inspection.
Right. And Bob, that's a good point. And I hear clients say this a lot. It drives me crazy. Well, they got a home inspection report. And what's your point? Well, they had an expert. No. Home inspectors are not experts. They don't even have to be licensed. Okay. So, as someone who has seen, I can't count how many home inspection reports. All I can say is some home inspectors are better than others. And we'll leave it at that. Okay. Because all home inspectors are doing, they're calling balls and strikes too. They're pointing out red flags. They know a lot of stuff, but they're not experts in any of them. And how many home inspection reports do you see where the home inspector is saying, hey, you need to go talk to a roofer. Hey, you need to go talk to an electrician. Hey, you need to go over here. You need to go over here, right? So they're just directing buyers to the appropriate third-party vendors, which is the same thing as the selling agent should be doing, as well. So I think the next question, Tom, was any forms that are creating issues in the real estate industry? Not really. And I know that's kind of a half answer. It is on a case-by-case basis. I don't think there's any one form that everyone in the industry is throwing up their hand saying, I don't know what this is. Okay. I've seen some difficulties with agents in the home hardening advisory, the defensible space issues. And I don't know, Bob, how many properties would fall, within that category of, yes, this is in a high density, fire area or not. Seems, obviously more rural properties focus and face that issue more than, let's say, urban properties. The form is pretty self-explanatory. There's no obligation of a seller to get, an inspection report from, a fire department, have them come out and walk the property. If the seller has a copy of that report, then certainly, and I think it's within 6 months, if I remember correctly, then obviously the seller, that's just another report that the seller is required to give a buyer. And I think the form also talks about a local ordinance. If there is a local ordinance that requires that pre-sale inspection report, then, that can really be negotiated, insofar as costs between buyer and seller. Generally, sellers are going to pay for that type of report. But the bigger problem, I think, and I've seen is, a lot of fire departments, whether it's city or county, is it LA Fire, right? Who's the proper fire authority to conduct that inspection? And I've seen sellers and even buyers run into some difficulty just trying to get an appointment to try to figure out who is the correct authoritative body to conduct that type of inspection.
My compliance officer isn't here today, but he will probably agree with me that about 70% of the buyer offers we get off of our listings don't understand that form. And then probably a good 80% don't get to the agreement part about who's going to pay for what if it's required. And they leave that blank because most of them don't know how to fill it out.
So what have you seen with the buyers' difficulty with that advisory?
Well, their agent didn't know what they were doing. So they didn't fill it out as, but if it needed to have the home hardening surrounded, it was blank. So then it's a term in the contract that is left, who's going to pay for it? Because if the listing agent didn't guide their seller properly on what it means, and if the buyer's agent doesn't understand the form, then that's a term that's still open in the contract, like a repair, that
Right.
who's going to make the repair?
Right, right.
And then even finding out if it's in a high or very high fire zone is confusing to most people.
Sure. So generally your NHD report, is going to, should.
And then we get confusion on the NHD reports.
Right. So I think the NHD report it's not going to have high fire density area in the, first 1 or 2 page summary. I think it's more buried in the reports further down. I don't think it's on the summary, the 2-page summary pages. Interesting point, Bob.
Yeah, we train on it extensively here, but it's the majority industry outside of these walls that don't understand it, unfortunately.
Right.
Because they're probably a 1 or 2 deal person a year at a small brokerage, and they're not trained on the new forms. So
Yeah.
Stuart, I was going to ask, what's the most common type of claims that you're seeing?
Well, I think that in first place, non-disclosure cases. I would say 90% of lawsuits are going to be non-disclosure of some physical problem, some defect, whatever it is. It can be fixed. It can be repaired. That's the most common. Unpermitted structures, non-code compliant improvements. I think a close second, but once again, that kind of falls under a non-disclosure category. The scariest of claims, and because the baby boomer generation is coming of age to where there are a lot of senior citizens who are selling properties, moving in with their kids, going to assisted living, etc. There is some turnover with that age demographic. Now, I have 3 financial elder abuse cases right now. They all follow the same or similar fact pattern. Now, mind you, to be an elder as defined by California law, you only have to be 65 years old to be an elder for purposes of the elder abuse statute. So the fact that, it's not granny 85 years old in the assisted living facility. No, it's 65. Okay. And they all follow the same fact pattern. And let's take mom in the nursing home situation, right? Mom in the nursing home isn't using emails and isn't using text messages. All right. So how do you memorialize certain things to mom the good old-fashioned way? Have her sign off on it. Well, now all of a sudden we get into a situation where mom has difficulty signing her name with a pen. Now what do? Create a DocuSign? Well, mom doesn't have an email account. Oh, well, let's get mom's adult son to create a DocuSign account, and then he can sit down with mom on his laptop in the nursing home and explain to her the certain documents, who's not a real estate agent, by the way. The son's not your client, mom is. So does mom give a power of attorney so that son can DocuSign things? That's preferable. Have express authorization. But most of these elder abuse cases are where these were her wishes. These were his wishes. He didn't like his kids. He wanted to disinherit his kids. Mom only liked the caretaker. So let's sell the house because mom wanted the caretaker to have the money and buy her a new house. And there's nothing in writing memorializing mom or dad's wishes. And so when the lawsuit's filed, it's not going to be filed by mom or dad because they're going to be dead. Your star witness is permanently unavailable for your case. Instead, we have adult kids coming in saying, where's my money? You took advantage of my mom. You took advantage of my dad. They had dementia. Here are the medical records. And real estate agents, and lawyers, we're not doctors. We're not neurologists. Maybe mom or dad seemed fine when we talked to them at the dining room table, but maybe there's a long history. They've got good days and they've got bad days that we don't know about. Okay. So you can't discriminate, or certain categories, as everybody knows, you can't discriminate against. Okay. One of those categories is age discrimination. And I'm not saying to engage in age discrimination and say, I am not going to take any listing with a person over the age of 65. I'm not saying to do that. Would it make me happy if you did? Yes. And it would also make Bob happy. It'd make Tom happy, because the reason why it'd make Bob happy is if and when you get sued on a financial elder abuse claim and it goes through the insurance adjuster, unfortunately, financial elder abuse, they're going to hire me to defend you, but Bob's going to get a letter called a reservation of rights letter that says, if the adult kids prove up elder abuse, there's no coverage. Insurance is not going to pay. There's no indemnity. So it's an uncovered claim insofar as indemnity is concerned. It doesn't affect you hiring me to do a dog and pony show and hope the jury likes me and likes you. But insofar as if it goes to verdict and it comes back, insurance isn't going to pay because it's not covered. Moreover, the elder abuse statute has a unilateral or one-way attorney fee provision in it. If the elder wins, and it's not even if you just assist someone else in the taking, namely money, of an elder, and you facilitate it, like how realtors can facilitate, right? There's an attorney fee provision to where the elder or the elder's estate, whoever sues, is entitled to recover their attorney's fees. If, on the other hand, which can be in the hundreds of thousands of dollars on top of maybe a couple more hundreds of thousands of dollars, if we defend an elder abuse case at trial, we don't get our fees reimbursed because that would be unfair for the elder who brought the lawsuit. Okay, so it's a hairy statute, and it has some practical consequences. So if you're going to deal with elder properties or elders who own properties who are looking to sell, be very careful, knowing and thinking to yourself, when my client, mom or dad, die and their kids come out of the woodwork, what is my file going to look like? Okay. And so how can you be more careful with elders? How can you be more sensitive? Ask your elder clients, do you have a trust? Do you have a will? Do you have estate planning? Are you working with a lawyer? Who's the lawyer? So you can involve and include the estate planning lawyer in your camp with your seller and talk with your seller's estate planning attorney and running documents through them. And obviously you've got to get express consent to do so from your seller. But most active sellers who have estate planning lawyers, they trust them first. And oftentimes elders will say, I need to send this document to my estate planning attorney for him to look at. I understand your explanation of it, but I want my lawyer to look at it. That's awesome. That's great. Great witness to have. Okay. Other types of lawsuits. Mostly non-disclosure elder abuse cases. Every now and again, there are procuring cause issues that come up, commission disputes that come up. That's kind of a sub factor because that's not going to be, litigated in court. But one thing that I will caution everyone is, I can't tell you how many times I have received a lawsuit from Tom, called my client, and a lawsuit's a story. That's all it is. Everybody's got a story. So I'll read the plaintiff's story. I'll call my client and say, what's your version? What's your story? And oftentimes I hear two things. The first thing that I hear is, all I was trying to do was help. I hear that all the time because realtors are helpful. You're providing a service. So that's a very common thing that I hear. But when I hear, all I was trying to do was help, the lawyer in me says, you were outside your lane, weren't you? You were doing something that you shouldn't have been doing, but you were just trying to be helpful. That's what I hear. Okay. The second thing that I hear is, I knew it. I knew it. I knew it. That's called intuition, my friend. That's gut instinct. That you knew that your buyer client was setting you up, and you're not surprised that this buyer filed a lawsuit. You knew it. That's your instinct, gut instinct. Listen to it. The buyers you can't make happy prior to close, you think you're going to make them happy after close? Not a chance. So on those transactions where you have that feeling, to all the agents, reach out to Bob. Bob's here to help. So don't be, the old saying is, there's no such thing as a stupid question. There's only stupid people that ask questions. Okay. But seriously, there are no stupid questions. Bob's here to help. If you have a difficult client, reach out, get guidance, get assistance, bring them on board.
One of the things you're saying is about non-disclosure being the one thing. Thomas, your materials, you had the 3-step disclosure process that I've been teaching a lot in the office too, about if the seller says the roof is 5 years old, how do you document that so that it doesn't prevent some type of case 5 years down the road because you put that in the MLS and come to find out it wasn't 5 years old. It was 10 years old.
Right. So I think the distinction there is roof is 5 years old versus seller says roof is 5 years old. Where you as the agent are saying roof is 5 years old, that's an affirmative representation. And if you knew it wasn't 5 years old, that's an intentional misrepresentation if it's older than 5 years, right? If you just threw it out there, it'd be a negligent misrepresentation, whereas identifying the source of the 5-year roof, seller says 5 years, as opposed to agent says 5 years. Two different messages.
Mm-hmm.
Robert, how are we doing on time? Just want to make sure
So we've got 10 minutes left of this session, and everybody on this call, we're going to run a few minutes over. I want to be aware of your time. Thomas is going to present some of the Crest benefits we have that are really good to help you in your business once we say goodbye to Stuart at the bottom of the hour. So we got about 10 minutes for the next question to cover, and then we'll move into the other stuff. If you can't stay, we understand it. It'll be recorded. And it'll be on YouTube, but it's not public. If you want to watch the rest of it, you got to get the access from Evie.
we will also be doing these webinars again. There's going to be a couple of them throughout the year. And you guys can also follow up with me directly if you have additional questions. But Stuart, what issues are you seeing with respect to removal of contingencies and demands to close escrow?
I'm seeing agents routinely not know what form is used in which scenario. They're very similar documents, but they're used for two different purposes. Notices to perform relate to contingencies. Demands to close escrow relate to escrow. I've seen many of agents use notices to perform, and on the other box, they say close escrow. Wrong form to use. Why? Because notices to perform have a 2-day performance and demands to close have a 3-day. So you're short circuiting from the seller side to the buyer 1 extra day to close escrow. That's one thing that I see. I'm also seeing notices to perform not being sent at the right time. Even on the seller side, if you're on the seller side of it, and let's say you get a backup offer that is more attractive than the offer that you're under contract with, from the seller side, there's only a certain times that you can cancel the contract from the seller side of the transaction, right? And so if you've got a backup offer, you want to hold that buyer's feet to the fire on the contingency periods, and you can serve notices to perform 2 days prior to the expiration of the contingency. So let's say it's a 17-day physical, you can serve that notice to perform on the 15th day so that it expires at 11:59 p.m. on the 17th day. And then at the strike at midnight, if they haven't removed that contingency, the seller can send over a cancellation and get in bed with the backup buyer. Selling agents removing contingencies without receiving a notice to perform. Oh, you're not saying that you have to wait for a notice to perform from the seller to remove a contingency, but oftentimes if you just remove a contingency prior to receiving that, you're also short-sighting your buyer time that they have under the contract for, let's say, additional inspections. Removing contingency when certain documents are outstanding. Seller hasn't provided all documents. Yep, but we're going to go ahead and remove the physical inspection contingency. Lo and behold, then there's a belated, delivered document, which then creates, some issues. Removing loan contingency or appraisal contingencies prior to confirmation in receipt of the appraisal or the loan. Failing to explain in writing the consequences of removing contingencies in the context of notices to perform, having that dialogue and that discussing. Also, it seems as though most notices to perform are coming from the seller to the buyer. I haven't seen, or I see regularly selling agents fearful for some reason or not knowing to use notices to perform against the seller. I see buyers agents, calling, emailing, texting, hey, where are the HOA docs or where are these docs? Okay, that's all fine and well. Informal asks are okay, but at some point in time, as the fiduciary to uphold and fulfill that fiduciary duty, your remedy is to send the seller a notice to perform. So both notices to perform should be going from seller to buyer and buyer to seller back and forth when the other side's not cooperating. Other than that, notices to perform, those are pretty much the issues that I see agents struggle with.
I appreciate that. I also want to make sure, I know we got just a little bit of time left here, but if anybody has any questions for Stuart, we usually open this up to a short Q&A at the end. So if anybody has any questions, feel free to ask them.
One of the questions was, is there any type of coverage that will protect you in an elder case, like EPI insurance?
Well, you'd have to talk to Tom. I'm not an insurance broker. I'm just a lawyer.
Not that I know of. Elder abuse is something that insurance companies do not want to insure. I can look into it further to find out. I'm happy to do that after this. But from what I know, at least with every E&O policy, with every carrier we work with, which is everyone in the industry, elder abuse is something that is excluded in writing the policy. And
the reason why it's excluded, Bob, is because it's an intent-based cause of action.
Yeah. There's also punitive damages in elder abuse too, isn't there?
And there's that component as well.
Yeah. Absolutely.
So you guys want to explain what the difference between compulsory and punitive is, so they're aware?
So there's compensatory damages. There are special damages, generally in the personal injury context, and then there's punitive damages. Compensatory damages in real estate cases is essentially a plaintiff's out-of-pocket expenses. How much is it going to cost to fix the roof would be their compensatory to compensate them damages, or if it's an appraisal diminution in value, that would be their compensatory to compensate them for their losses, financial losses that they've incurred. Special damages, physical injury, emotional distress, loss of consortium, that kind of stuff. Don't really see a lot of that. Maybe on a trip and fall, slip and fall, open house case, maybe. Punitive damages in California is governed by Civil Code Section 3294. And that statute says that if there is evidence of fraud, malice, or oppression, those are three bad words. You don't have to look them up, but you hear fraud, malice, oppression, not good. If a jury finds, and that would be an intent-based damage model, intentional misrepresentation, concealment of a known fact, and it gets proved that you concealed or intentionally misrepresented the condition of the property with malice or oppression or fraud, then a jury can award punitive damages. And the punitive damages, in addition to compensatory, punitive damages at trial is what's called a bifurcated, two-phased trial. So after the jury comes back and said, you committed elder abuse, and we award plaintiff X amount of dollars, then we start the second phase of the trial for punitive, and they find punitive damages. And then you're going to get on the stand and you're going to open up your checkbook and you're going to open up your portfolio and you're going to tell the jury how much money you have. That's privilege. No, it's not anymore. And so the jury's going to get a look at what your net worth is. And based upon your net worth, depends on how bad you were, they're going to send a message that hits you in the wallet. Send a message, you shouldn't be doing this. So we're going to hit you where it hurts. Nobody cares more about your money than you. And that's what punitive damages seeks to penalize and send a message that this is bad behavior that you shouldn't do. Now, Tom, on the other hand, if that verdict comes in, the next day or week, they're going to hire another lawyer, not me. They're going to hire another lawyer to go into court on a declaratory relief action. And they're going to ask the court to declare, they're going to walk in with the insurance policy in one hand and the verdict in the other hand. Insurance policy says, we don't pay for fraud. We don't pay for punitive damages. The other hand, they got hit for fraud. Jury awarded punitive damages. And Thomas's other lawyer is going to ask the court to declare that Thomas doesn't have to pay. And that's on you. And the judge is going to sign off on that. And unfortunately, any money judgment that is entered against someone that is based in fraud is not dischargeable in bankruptcy. So,
okay, well, let's do it. I think they're going to have to go clean their pants now. So we got two quick questions.
Yes, sir.
One was from Amy and then followed by Chris. Amy first, because I saw yours and you put your hand down.
Yeah, I put it down because I forgot my question, but I remembered it. Okay, so here's a question about buyer removal. So I'm in a 14-day escrow. The seller did perform on time to order the HOA docs. However, with the 14-day escrow, the docs did not come in to give them the full 7 days to remove that contingency on review of documents, so here's the timeline. We opened escrow on day 1. The buyer removed all their contingencies with the CR on day 7. They received HOA documents 3 days later that only gives them 3 or 4 days to review before closing. Do we need a new CR to acknowledge the HOA docs? Do we extend the close of escrow?
No, because you've already delivered a signed CR that is associated with documents that you hadn't received when you removed it.
Mm-hmm.
So that's what I was saying earlier, when contingency removals are used, right? prior to receiving the documents, prior to receiving the appraisal. Yep.
So
gonna
they're just
remove the-
risking that there's something on the HOA docs that they don't approve. They got to take it or leave it. That's a non-contingent reason to cancel now. Is that correct?
Correct.
Okay,
correct.
I represent the seller, so I just want to make sure that my seller's not going to have to postpone a closing because the buyer needs 2 more days to review before they come back with a new CR. Okay, thank you.
Chris,
Really quickly, I send a lot of emails, because Robert has beat that into my head, but I've had at least one client where, let's say I send an email that says, okay, based on the inspection, you should get the sewer line scoped, right? I mean, I do that one anyway, but whatever. I had one client who would never acknowledge an email, but then just start a new email on a completely different subject. So they were probably very smart, but say I sent that email, I can prove I sent that email, whether or not they replied to it, and then tried to sue me. If I bring that in and say, well, I sent this to them, and I said, based on our conversation, XYZ, I mean, like, what do you do in that case if they try to sue you? Could they say, well, I never got that email, or like, what does that look like?
Well, it would obviously be their burden of proof to establish that they didn't receive it, right?
Oh, okay.
You're saying, here's our email, here's
Mhm.
my email address, here's their email address. It never bounced back. It's presumed to be delivered. To the extent you have a read receipt function on your email program, I would utilize that. So once they click it, you get an email back saying it's been read. Essentially, it's been opened.
Gotcha. Okay, cool.
I do want to get this last question in because this is important, because Thomas will agree on this. Do you see more lawsuits on flipped properties?
As an underwriter who reviews claims all the time, I can tell you we do see a healthy portion of claims related to flipping. You know, typically when you're dealing with a flip property, you have somebody that's trying to maximize their profits and lower their overhead. They did not live in the property. They don't have a full understanding of everything that took place. And depending on the person, they may not go through all the necessary steps to be careful. So we do see a higher amount of claims on flip properties.
And on flip properties, I've represented many of clients who were the selling agent representing the buyer on flipped properties. And they rely exclusively on the seller's disclosures, really about permits, things to code, not to code, right? So if it's a flipped property, you're going to know it's a flipped property, right? On flipped properties, you better, on the selling agent side of the transaction, you better have something in writing that says, hi, client, as you know, this is a flipped property. Okay. The seller has indicated that they're unaware, the seller who did the flip, by the way, they're unaware of any work that was done without permits. Well, if they're the ones that did the work, they would know whether or not certain things were or were not done with permits. Well, they said no, therefore everything is permitted. The fact that a seller says, I'm unaware of any work that was done to this property without permits doesn't mean that the work that was done with permits. You see the distinction there? So on the selling agent side of the transaction, you better have something in writing to your client, telling your client to go down to the city or the county and pull the permit history of the house.
I'll actually be jumping into that topic here in just a moment.
Yeah. And Thomas has similar reports as well. Enlist the services of a general contractor.
And we actually have a flip advisory too, that they
Perfect.
should be presenting and discussing with the buyer before they make the offer about the perils of purchasing a flip. Stuart, we want to thank you for your time, and I want to be respectful of people that can't
You're
stay.
welcome.
Appreciate it. And we're going to get
You're
into the next part. If you can't stay, this will be recorded. If you want to stay, we're going to learn all the benefits that Crest has to help you stay out of court. and also grow your business. Thanks, Stuart.
You're welcome.
Thomas, take it away.
Yeah, thanks, Stuart. Really appreciate it. Yeah, so a lot of good topics were just discovered. Discussed, and a lot of those pertain to what I'm about to talk about. I'd mentioned earlier in this meeting that Crest has a comprehensive program, and we provide more than just coverage that protects you when you have a claim. At that point, it's already too late. You're filing a claim, you're paying your deductible, whatever amount that is. Sometimes it's $5,000, $10,000, $25,000. Claims are not a short process. They can last from months to a few years. So there's a lot of sleepless nights involved, and it's going to affect your insurance premiums for the next 5 years as well. So Crest wanted to come up with a program that didn't just protect you when things go wrong. We wanted to create some products and services that can help keep you out of the claim altogether. One in particular that I want to discuss with you guys is our seller's E&O insurance. This is different than you representing the seller as the listing agent. This is a separate E&O policy for the seller. And normally a seller cannot get E&O insurance without being a licensed professional. And we are the only company that offers this. So not only does this protect you by keeping you out of the claim because the seller has their own policy to tender a claim to in the first place, but it's also a really good listing tool. By building it into your listing presentation and letting the seller know that, by working with you, you're able to give them the type of coverage they normally can't get. Is it okay if I share my screen?
Yes.
All right. So this is one of our seller's E&O certificates. And you have the ability to get seller's E&O a couple different ways. We are partnered with a few different major companies, 2 NHD companies in particular, which is My NHD and Disclosure Reports. And if you use one of their NHD reports in your transaction, then the seller gets $25,000 in seller's E&O insurance. The Crest NHD report is no difference. There's no difference in price between their regular report and the one that's a Crest report. So since it's a requirement in California to have an NHD report on all residential transactions anyways, you might as well use one of Crest's partners so that you can get the seller this benefit. So what it is, it's an E&O policy that covers the seller for their primary residence. It's not intended for investment properties or rentals because it's a policy that basically covers disclosure issues, which is the bulk of claims that get filed. So we want to make sure that the sellers have a good understanding of the property. And if they didn't live in it and it wasn't their primary residence, there may be issues with the property they're not aware of. So an important part of this is it is primary residence of the seller. But the seller gets $25,000 in coverage for 180 days after the close of escrow. And they have the option to extend it an additional 180 days, so almost a full year, for $200, which most choose to do. It's a pretty nominal cost to have that type of coverage. So the seller, if they were to get a demand from the buyer, they would file a claim under this. They would contact us and just file a claim. They have a $2,500 deductible that they would need to pay, and then their seller's E&O insurance kicks in. And so what you would do is you would print off a nice copy of this certificate, so you can bring it with you into your listing presentation. And I did want to mention that if the Crest NHD report is utilized in the transaction, it doesn't matter which side you represent. So you can represent the buyer as well and still have this afforded to the seller. But what you would do is you would bring this in and you would complete the broad portion here of this certificate and give it to the seller. This is their proof of insurance. The vertical tearaway stub on the right-hand side, you would fill out and keep in your transaction file. And if the seller wants to extend the coverage for an additional 180 days, they just need to make the request within 15 days after the close of escrow. So it's got to be something that they determine up front. They can't wait 5 months and then say, now I want to extend it. It's something they need to decide in the beginning. And I'm going to cover quite a bit of information here, and I'll be doing it pretty quickly. If anybody has any questions, feel free to ask. You don't need to raise your hand. You can just unmute yourself and ask me. And that way we can speed this along, because I know you guys are busy and we're short on time here. But if anybody has any questions, just let me know.
So this is only for their primary residence.
That is correct. Yes. Yeah. Because of the disclosures, we want to make sure that if we're going to provide the insurance to the seller, that they're going to have a good understanding of the property. So that's an important part of it.
So if they didn't live in the property, but that was their primary residence, it cannot be used for that.
It would be unlikely that if it was their primary residence and not living in it. I'm trying to think of a situation where that would be the case.
Well, we have a lot of that here in
Okay.
Coronado. About 40% of the properties are second homes and they're not living in them half of the time.
Then they're a second home. They're not
That's
primary.
a second. Yeah.
Oh, you're right. Well, some of them actually, well, some of them are primaries and they live somewhere else, but okay.
And that's their secondary. So if it's their primary, then great. But if it's not their primary, it's their secondary.
It's a good point, though. It's a good question to bring up, because so one of the requirements with the seller's E&O insurance is that the seller must have lived in the property at least 90 days before the escrow. So they couldn't have moved out of the property 4 months before the escrow. They would have had to have moved out within that 90-day period for it to be considered their primary residence. So I'm just pulling up here a flyer. This is the My NHD flyer for the product that they sell. No difference in price here. So, you know, again, if you're going to use an NHD report, which you're required to do, you might as well use one of our partners so you can get that added benefit. And there's ways to increase the amount of coverage you get with the seller's E&O insurance. So we are partnered with 3 home warranty companies in California. Old Republic, Fidelity National, and First American. And there's a couple advantages to using one of the home warranties through their program. So if you use a Crest home warranty through any one of our partners, you get a 13-month home warranty rather than a 12-month. It automatically comes with a deductible reduction of $5,000. So if you guys get a claim for any reason and you had a 13-month Crest home warranty on your transaction, it would reduce your deductible by $5,000. And the seller also gets an additional $50,000 in coverage. So I pulled up one of the brochures for one of our home warranty partners. So this one being Fidelity here. You'll know it's a Crest home warranty because it's the only home warranty that comes with 13 months of coverage. They also have some enhancements in their coverage. Some of them provide like structural or roof coverage as well. And you'll also notice that there is the Crest logo on it. So it's important to make sure you're getting the right one. And if you work with your home warranty representative, they'll know which one to place you with because they're very familiar with our program. The seller's E&O that comes with it looks just like the other certificate. So this one is $50,000 in coverage though. So if you were to use the NHD report through one of our partners and a 13-month Crest home warranty through one of our partners, then you're able to provide your seller $75,000 in coverage. All the same rules apply. So it's for the primary residence. The seller has a $2,500 deductible if they file a claim, and same with extending it. So if they want to extend it an additional 6 months, it's going to be $200 to do so, and that would be $200 for each certificate. Sometimes we'll have, maybe the seller only wants to extend one of them. So we always recommend, then have them extend the one with the home warranty so they're getting the $50,000 extended and not just the $25,000 extended. But this product has been crucial in helping our clients stay out of claims. It really does keep you out of it. And you might say, $25,000 in coverage or $50,000 in coverage, it doesn't sound like a lot of money. Well, we have found that in majority of claims, we can resolve them for under $25,000. And even better, if they have 50,000 in coverage, then that's even better. But, usually the buyer, they're making an emotional purchase. They're buying their dream home. They're starting a family. They can't wait to move in. They've got all these changes in mind that they want to make. And then they go, open the wall in the kitchen and find out there was a water intrusion and there's mold in the wall and nobody disclosed this to them. And it's going to cost me $20,000 to get this resolved. So the seller's E&O insurance is intended to, basically make the buyer feel whole in having them recover some of the costs that they believe they lost with the diminished value of the property. And then what our adjusters will do is we always try to get a release of liability signed with the settlement. So to keep you out of future claims. So not only are we going to try to keep you out of being in this claim in the first place, but we want to try to keep you out of claims going forward. And
So it's kind of like a claim protection mechanism. Because both buyer and seller don't end up lawyering up and we end up in mediation.
Correct. Yeah. So what we see happen most often is, the buyer will it's almost always the buyer making a demand against the seller. It does happen the other way around, but it's usually that way. The buyer makes a demand against the seller and the seller either can't afford to meet the demand or just refuses to. So then the buyer will go hire an attorney and the attorney says, nope, you need to name everybody that's licensed and involved in the transaction. So name the brokers, the agents, name the home inspectors, name the appraiser, they basically pull everybody in. And what gets so expensive with real estate claims is the defense costs. There's going to be depositions. There's going to be mediations. Hopefully it doesn't get to a trial, but if it does, that's when they get extremely expensive. And so if we can keep you guys out of the claim and having it escalate like that and become very expensive, it's all the better for everybody. So the main goal here is to keep you out of the claim from the beginning. And these products have really been crucial in keeping our clients out of claims. They're very effective.
Perfect. I like hearing that.
We're the only company that offers this, and we've been providing it for over 20 years.
Well, plus it's a great listing tool if you bring this in as part of your listing packet. So
yeah, because if you're letting the seller know, look, by signing with me, you're able to get coverage that you normally can't get. Why wouldn't they sign with you? And you only Crest members have this. So
perfect.
We spoke during the risk management portion. We spoke a little bit about disclosures, and we also tied in permits. So what happened was we partnered with a company called BuildFax a few years back. BuildFax is like the Carfax for residential and commercial properties. And we found that about 20% of claims are permit related, which is a pretty high percentage. Whether it's an unpermitted bedroom, balcony, it can be a wide range of different permit related issues. And sometimes the seller's not even aware of it if they didn't go pull permits themselves. So what we did was we partnered with BuildFax, and through BuildFax, you have the ability to pull a detailed permit history timeline. And you might say, well, we're not supposed to go pull permits. This is not pulling permits. This is not the same thing as going down to the county or city and pulling them yourselves, which you should never do. Because if there is something wrong with it, you're assuming the liability from the get-go, and the insurance just pays out. We can't even defend it. But what this is a detailed permit history timeline. It'll show you the property information, their address, the amount of permits that were applied for on the property, the time span in which they were applied. And on the second page, there's a disclaimer. This is the most important part of it. So the disclaimer advises the buyer to go pull permits from the city or county themselves. So they're being advised to only use this as a reference and to go do it themselves. After the disclaimer, we get into the list of different permits that were applied for, what they were for, when they were applied, what the outcome was, what the job cost was, You know, was it abandoned and expired? Was it declined? Was it finalized? And so there'll be a whole list of permits depending on how many the property has. And then we have the disclaimer again. So this time the disclaimer has a signature section. So you'll build this into your disclosures and have the buyer sign off that they understand that they're supposed to go pull their own permits from the county or city. So they can't come back later and say, well, my agent didn't tell me to do that, because that's usually why we see permit related claims. This is an extra risk management step. So when you pull a permit report and have the buyer sign it, you're adding protection to yourself and being careful. So we reward that. If you were to get a claim for any reason on a transaction where you pulled our permit report and had it signed, then we will reduce your deductible by $2,500. So if you're using the permit report and you're using a Crest home warranty, that'll reduce your deductible by $7,500. And we give these permits to you for free. So you might as well use them, might as well pull them. The only advantage to this is that you're keeping yourself safe and helping yourself avoid permit related claims. Oh, sorry, I was reading a message, but yeah, that's about how to pull them. So yeah, you'll have designated people in your office that'll pull these for you. And it's a really quick process. You type in an address, the permit report pulls up immediately, you download it, print it off and build it in. So we were discussing risk management with our attorney. So Stuart, he works with Carlson Law Group. They're one of the law firms that we use, but we do have a few. And a part of our program is our risk management services. So we have a panel of attorneys that you have access to 7 days a week, and they're available to you for phone consultation, contract and document review, as well as writing attorney letters on your behalf. And it's for any pre-claim matters. So, you know, if you have a demand for money or service, that's technically a claim. You can't use risk management. It would have to be a pre-claim matter in order to use the service. And they're available 7 days a week, which is really great. If you get into a situation where you're at an open house or a showing and you need to speak to somebody, you can call in and have one of our attorneys will call you back to answer any questions. This also satisfies a requirement under your E&O insurance. So E&O is a very unique type of insurance. It's written on what's called a claims made and reported basis. It requires that you report any issues to the carrier during the policy period in which you become aware. And the reason that this is important to you is you can have a coverage issue if, let's say, you have a situation that's brewing between your buyer and your seller. You know, you don't have a claim yet, but they're already talking about lawyering up. And this obviously is going to go somewhere. At that point, you're required to notify your insurance carrier. It doesn't mean you're opening a claim. It just means you're reporting it to us. And that way, if let's say in the next year or two, this does turn into a claim against you, you're not being denied coverage for failing to report it to the carrier during the same policy period. So we will log it, we will track it. And then if you need to tender a claim at a future date, you know, then there's no coverage issue associated with that. There's also nothing negative associated with it. So the risk management services are not provided to have a negative impact on you. You know, we're not going to increase your premiums for using it. We're not going to change your coverage for using it. The intent of having the risk management is to help you stay out of the claim altogether. And if we're able to help you stay out of the claim, it's a win-win for everybody. So I can't stress it enough. If you have situations that you want to get legal advice on, this is available to you and we encourage the use.
I've already used it already with the question about wholesaling, which has been popping up a lot with a lot of agents are being hit up by wholesalers to sell properties to their flip buyers.
Investors.
And it's just too much risk in it.
Yep. Yeah, absolutely. And so, you know, you can get, I mean, I mentioned before, not only they'll do like contract and document review and write attorney letters on your behalf, but just getting the advice from an attorney can give you the peace of mind and confidence to move forward in a transaction and know that, you were advised by somebody who is licensed to do that, to give you that type of advice. You know, you can either email the risk management department, or you guys can call in. What we do is we set up a risk management ticket, and then an attorney will get back to you within a 4-hour business window. It's usually quicker than that, but we say a 4-hour business window because they are working attorneys. They might be in court, they might not be available at that very moment, but they will get back to you soon. And then they do risk management webinars, as you guys saw today. So that's something we'll be setting up quarterly for you guys. And last thing I wanted to show you here, so we created a checklist. The intent of this is to help you guys track which benefits you use in your transaction. So if you ultimately end up having a claim, you're not trying to go back and look through and see what you used, you know, how much, which benefits are providing the deductible reduction. It'll all be here in one place. And so we recommend you guys using this and keeping it in your transaction file.
And then Thomas, can you send me each one of these documents so I can send them out to everybody?
Absolutely. Yeah.
I know I have access, but I got to filter through all these other links to get to it.
No, not a problem. I will, I'll send an email after this with a detailed explanation of all the benefits we provide, and then also all of these attachments, so you guys have them for reference.
So you guys will have this sent out probably tomorrow. It'll also have these questions we went over today too, with some more notes on it. So look for that. Thomas, I appreciate your time today. We have a hard stop because we got to use this line for another call in a minute, but really appreciate your time. We're glad we're back with Cress, and we'll have you back in again soon.
Sounds good. Yeah, and if you guys have any follow-up questions, just let me know. I have an open door policy.
Thank you very much. Thank you, Tom, and everybody else have a great day. Glad you